Thank you very much, Jackie, and thank you for that, Paul. It's interesting to see that, and also about the land acknowledgement. I wasn't expecting one, but I'm very happy that you did. If you want to learn more about these land and the different groups that have been here for thousands of years, there's a lot of information in the website of the City of Toronto, and you can Google the treaties. Sometimes I start looking for treaties, so these agreements between the, just let me share my screen here. Okay. All right. So talking about the treaties, I always think that these agreements are in writing, like with letters, but the agreements between Inuit, Métis, and First Nation peoples with government are more like images and art. So it's the interpretation of those images and art that you can actually see in these websites. All right. Thank you, OneHub, Eddie, Jackie, Sean, for having me here tonight. I'm very happy to have this setting for talking about a little bit about employment rights, the minimum standards at least, which is a small piece of the whole puzzle. And yeah, thank you for allowing us to be together, and for all of you who are here spending your night with us on a Thursday night. Thank you for taking this time. I hope that this time is valuable for you. The information today is it's not legal advice. It's only legal information for guidance purposes. If you're experiencing something related to your workplace in particular, or if you're an employer or an employee and you need to find answers specifically for your situation, I encourage you to contact an employment lawyer to get those answers in particular. If you act upon the information that you received today, you may be creating more difficulties instead of solving problems, because each case is different. My name there, Antonio Urdaneta. I'm the founder of Workplace Legal, which is a framework that assists workplaces in different things about employment relations, labor relations, which includes unions, and workplace human rights. Within employment relations, I include health and safety. All right, let me do a little poll with you now. And just by putting in the chat, if you can put in the chat whether letter A, letter B, or letter C, where do you think your rights as an employee or as a freelancer, independent contractor come from? Do you think it comes from the province of Ontario? Do you think it comes from Canada, the country, federal government, or does it come from another province or territory? Just put A, B, or C in the chat. I'm looking at the chat right now. Okay, A, Ontario, okay. B, Canada, all right. All right, keep throwing the letters there. I'm happy to see that. The answer evidently will be, it depends. And I want to start with this because there are different things that would tell you what the source of your rights are. It could be federal, it could be Canada, so it could be B. It could be provincial, it could be Ontario. So A. Now, getting back to 1867, and I'm not going to talk about 200 years of history, but getting back to 1867, when the Constitution was drafted for the first time in Canada, different things were given to different powers or different authorities. So some things were given to the federal government and some things were given to the Ontario government and other provinces. So for example, banks, it's something that the federal government has authority over. But insurance companies is something that provinces have power over. So both of them, federal and provincial governments, can actually put out their laws that deal with employment, whether in banks or in insurance companies. So it depends on whether the business where you are working what type of business it is that you would be, whether your employment relation would be controlled by the federal government or would be controlled by the provincial government. And when I say control, is with these minimum standards that we're going to talk about today. Another thing that would affect what type of law or what rights you have, it's the type of work that you do. And I was talking with Eddie before we started today that I've spent probably 6 hours already trying to find out whether a person is a residential care worker or the person is a domestic worker. And I just bring that example to suggest to you that it could be that you're just an employee in a company and that's that, but it could be a little bit more complicated than that. It could be the type of work that you do that will give you more rights or will actually take rights that you don't have under these laws that we're going to talk about today. With this first slide and this first conversation that we have now, I want to tell you that it may be very general, the employment relationship that you have, and it could be covered by the Employment Standards Act with no exemptions. But sometimes the type of work that you do and the business that you work for can change that and make it a little bit more complex than what it seems. All right, another poll. Again, you can throw the answers in the chat and let me know what you think about this. Your wages and your hours of work, your wages and your hours of work. Where do you think those rights are? A, in rules or laws, B, in an employment contract, or C, in collective agreements? Let's see, A, B, or C. B, employment contracts, okay. All right. Okay, we have employment contracts, okay. A and B, great answer. All of them, thank you, Lori. All right. So yeah, it's pretty much all of those answers, A and C. By the way, just throw in the chat a Y for a yes or an N for a no if you want me to explain or you don't want me to explain what collective agreements are. If there is somebody who want me to talk a little bit about collective agreements, I can do that as well. All right, I'll talk about collective agreements. But before I go there, let's talk about wages and hours. As long as the employment contract is better than the minimum standards, as long as the employment contract is better than minimum standards, then the employment agreement, the employment contract would say your wages and the hours of work. But if the employment contract is lower as rights, so let's say the minimum wage in Ontario, it's $15 an hour. I'm not sure that that's the number, but let's say it's $15 an hour right now. And your employment agreement says that you're going to be paid $14 an hour. You cannot contract out of the minimum standards, meaning that even though if you sign an employment agreement that says that you're going to be earning $14 an hour, that $14 an hour is not valid because in Ontario, there is a minimum standard that people needs to be paid at least $15 an hour, and that may change over time. It has been changing for the past few years. So it could be both the employment contract or it could be the minimum standards rules. So that's about wages. Talking about wages and getting back to that federal or provincial, if you're working for a company that it's federally regulated, for example, if you're working for Canada Post or a similar company that it's about logistics across provinces or across countries, right? That's going to be federally regulated, the logistic company across provinces or across countries. The minimum wage that would apply is the minimum wage of the province where the work is being conducted, it's being done. So if the person is in Ontario, packaging in Ontario or distributing in Ontario, then the minimum wage for that federal undertaking will be the minimum wage in Ontario. And the same thing will apply for every province and every territory. So what I want to say with that is that the federal government doesn't have a minimum wage. Whoever sets up the minimum wage is the provinces, all right? Talking a little bit about hours of work. For hours of work, there are different things that we need to be mindful of. First, the maximum hours of work. So the maximum hours of work in Ontario is 8 hours per day, 44 hours per week. That's generally speaking. But there are different types of work. Talking again about the type of work that you do, that is not at 8 hours work that it's the maximum. It could be 12 hours shifts. And for example, security personnel could be within the 12 hours shifts. Healthcare professionals could be within the 12-hour shifts, and others. So it could be whether the general one, which is 8 hours per day, up to 44 hours per week as the regular hours of work, or it could be something different, or it could be a nature of work that requires a different type of measurement for the hours worked. One thing that I want to say about this is that there needs to be a minimum hours of resting periods. So the time between shifts, if we're talking about you have 2 shifts in a 24 hours window, right? Between shifts, for the general one, between shifts, you need to have at least 11 hours of resting before you start the new shifts. But there are, for example, the healthcare, some nature of healthcare workers that they have 12-hour shifts in a 24 hours period. So they may start shifts consecutively. The important thing for them is that they have at least 36 hours of rests between an amount of days worked and an amount of days work. So what I want to say with this is that be mindful that the type of work that you do would say whether you are within the general category where 8 hours of work, 44 hours a week, it's enough, it's maximum, or you are in a different category where those hours are not the 8 hours a day are not the ones that apply to that type of work. There are other things like for minimum wage purposes, if you're a student, an intern, an apprentice, those type of labels, and evidently not just the label, but the type of work that you do, the minimum wage for that work, it's different from the regular minimum wage. So if we're talking about minimum wage for the general rules, it's $15. For apprentice could be $13.50, something like that. It's just an example. Another thing that I want to say about hours is that in Ontario, if you cross as an employee, if you cross certain hours of work during the week, so the maximum, let's say in the general category is 44 hours. If you cross that maximum, then the additional hours that you work during that week are going to be considered as overtime, and that requires to be paid at a different rate. And the rate is 1.5, the value of the hourly rate of the general one. So if you earn $15 an hour, which is the minimum wage, then the 1.5 for the overtime pay would be, so we divide 15 by 2 is 7.50 cents. We add it to the regular hour of work, which is 15. So we're talking about 22.50. So your overtime in those circumstances, your overtime pay for every hour that you work over 44 hours, it's going to be $22.50 instead of $15. Another thing that I want to mention, and a lot of people forgets about this because it seems silly, but it is very important. Ontario says, I mean, the laws in Ontario say that you could work overtime pay from 44 hours to 48 hours. So just 4 hours overtime per week. If an employer needs, and that happens sometimes, if an employer needs to have the workforce working overtime over the 48 hours, they need to ask for authorization to the director of the Ministry of Labor. That doesn't mean that they're going to have to ask for the authorization and the director is going to deny it. It's just that they need to give the notice to the director that these workers are actually working over 48 hours. A lot of people forgets about this and they just worked 52 hours, 60 hours, 75 hours, but there is this silly paperwork that needs to be, I say silly, but it's a matter of controlling the economy and all these things that are around the employment relations. All right, so that's about wages and hours. If you have questions about wages and hours, we can answer it now or maybe later. Talking about the collective agreement, syndicates or unions. The words that I use here is unions, which is a group of employees that they organize and they form what it's called a bargaining unit, meaning that, let's say 10, 20, 30 employees that do a similar work would go together to the employer and say, we want to have an employment agreement that it's not individual with each one of us, but it's a group type of agreement. So that's why they call it collective agreement. And there are benefits and there are pros and cons of having a collective agreement in place. There is a lot of protection for collective agreements for employees, talking about seniority, about specific negotiations with the employer. An individual employee may lose a lot of that flexibility that an individual employment contract has. But yeah, so that's what collective agreement means. A group of employees represented by a union, would negotiate with the employer a group contract instead of individual employment agreements. All right, if you have questions, just throw it in the chat. I think that Jackie said on a first time, first served basis, apparently. All right. And if you have comments, questions, just throw it in there. And if you want to unmute yourself and make a comment, I'll be happy to listen to somebody. I just see boxes without faces in my screen, so I don't know if I'm talking to people or to technology. All right, but okay. So let's talk about public holidays and vacation pay. In Ontario, there are 9 holidays throughout the year, and minimum standards require employees to be paid holiday pay, which means just pay for the day. But if the employee works that day, then the employer will need to pay that day, the hours that the employee work, on a premium basis, and that premium basis has a formula. It's a little bit higher than a regular hour of work, but yeah, that's if the employee works. It could be paid with money or it could be paid with time. So if you didn't take the day off because of the type of work that you do requires that you are there, then you can take the day off at a later date. That's for public holidays. Now, every province will have different public holidays, and the federal government also has a different group of holidays. They may overlap, some of them, but not all of them overlap. Talking about vacation, it's how can I say this? Vacation, it's complicated or complex. I mean, it's a matter of paying attention to vacations, because from vacation, there are two things. There is time, so enjoyment of the vacation time, and then there is vacation pay. Vacation time has some rules. Employers could say, and that's okay, employers could say, you are going to be paid per year this amount of money, and that includes vacation. So every time you go on vacation, let's say for a week or 2 weeks at a time, it's 2 weeks for people with less than 5 years of tenure, length of work. When you go on vacation, you're going to be paid like a salary, but instead of the salary, that would be the vacation pay. Sometimes vacation time and vacation pay are not aligned, or let's say that the employee is working with the company for, I don't know, 16 months and never enjoyed vacation time. The person may have lost that vacation time. Employers do not have to pay twice vacation time. What employers have to pay is vacation pay. And vacation pay is measured this way: minimum 4% of the salary. So every time a worker completes an hour of work, already earn 4% of that hour of work. So if it's 15%, $15, it's 4% of that, of those $15. So the employee is always generating that 4% for the time worked already. So if by the time this employment relation ends, let's say 16 months after starting, then the employee will receive, if the employee was not paid already, the employee will receive at the time of termination 4% of what the employee earned as a salary, as a wage during the time working there. So that's vacation pay. Vacation time, again, it has certain rules, and it needs to be enjoyed within a period of 18 weeks. I'm sorry, 18 months. So let's say that, let me back up. Vacation time needs to be, it is accounted for, this is a better way of expressing it, it is accounted for every 12 months. So every 12 months, an employee will earn the right to have 2 weeks of vacation. How they enjoy that vacation, whether 1 week at a time or 2 weeks together, that's up to the employee and the employer. But if the employee doesn't enjoy the vacations in that, specifically at that time after the 12 months, the employee can enjoy the vacation time up to 18 months. So in that window of 18 months, the employee will need to enjoy the vacation time. Otherwise, they may lose that right of the vacation time. So that's why it's important. If you have questions about public holidays or vacation pay or vacation time, I'll be happy to answer those. Leaves of absence. The leaves of absence structure, and please let me know if you want me to explain a little bit more with a Y or an N in the chat, if you want me to explain a little bit more what leaves mean. But leave of absence, there are about 14 or 15 types of leave of absence in the Employment Standards Act, in the minimum standards. And that could include taking care of a family who is ill and requires care. That could be illness or bereavement. Somebody passed and you need to attend the funeral, for example. That could include military service. That could include and there are many others, like the ones that we have here. We have sick, maternity leave, and parental leave. I bring these two, just as these three as an example, because, for example, for sick leave, we're talking about days only. So you have in a period of 12 months, you have 2 days or 3 days of sick leave entitlement. That means if you get sick at a 4th day, then you don't have the right under the Employment Standards Act. There could be other things to use, but not the leaves of absence, sick leave. But so that's days. On the other hand, parental leave. So when you become a guardian or a parent of a kid, whether it is biologically or adoption or other way, you become the guardian of this child, then you're entitled to parental leave. And these parental leave can be months at a time. We're talking about 60 to 70 weeks. So it could be more than a year. The thing with the leaves of absence is that if we're talking about these type of leaves, the ones that are in the Employment Standards Act, these leaves of absence are job protected, meaning that the employer cannot terminate an employee because the employee is on a leave of absence. So that job is protected. Evidently, there are things that may be happening in the business is reorganizing in that position, or those positions are no longer available, but that's a different story. In general, the employer will need to protect that job for the time of the leave of absence and reinstate the employee to regular work when the leave of absence expires. These leave of absence are unpaid. An employee is not going to be paid by the employer because the employee will have to apply to the the employment insurance programs or other programs from Service Canada under different programs that the federal government has that supports these leaves of absence. So if for parents, it would be a percentage of the salary. For new parents, it would be a percentage of the salary that employee was earning during work. During the leave of absence, it will be a few 60% or 55%. Let me see this comment here. I had a friend who was terminated but was given termination pay near the end of her leave of absence. Could you explain that? Well, I mean, I could explain it different ways. I will have to read the documents and the termination and the agreements and all of that. There could have been a settlement. The employer offer something that this friend of yours couldn't refuse and accepted that. It could be that there was a reorganization of the business and that line of production disappeared and there was no other way of bringing that employee back to the business to do something. It could be many things. The general rule is that the employee needs to be brought back to the place of work. So I'll be happy to talk with your friend. Was that a long time ago or it was recent? Okay. It was covered by the Employment Standards Act because you counted how many years? So it was recent, that termination, or it was a year ago or 2 years ago? Oh, 10 years ago. Okay. Okay. All right. All right. Thank you. Thank you for sharing that. And it's a good example, right? So sometimes, I mean, it is a job protected unpaid leave. That's the general rule. But to the general rule, there are some exceptions. And sometimes the employer needs to move on and offers the employee, something in exchange for accepting that termination. By the way, now that you mentioned 10 years, there are time limitations to bring complaints against the employer for wages or for vacation pay or for all these things. So 10 years will be out of that time limitation. But so if there are concerns about this, it's important that you bring your concerns quickly to your employer first. And if the employer doesn't fix that or doesn't give you an explanation that seems reasonable, then the Ministry of Labor is available for reviewing that concern. But it needs to be within a window of at least 2 years. So if you are over 2 years, then the employer cannot, the Ministry of Labor, excuse me, cannot make a decision. All right. So there are leaves of absences, a lot of them. On top of the leave of absence, and this is a little bit of overlap, workplaces are expected to comply with human rights. And when I say human rights, it's not, I don't want you to think about this universal declaration of human rights with protection of human trafficking and things like that. It's a little bit different when we talk about human rights in the workplace. We're talking about not discriminating against people, employees or others, and not harassing people because of personal characteristics that are not related to the job itself or the abilities or the skills, right? So we can talk about race, color, ancestry, place of origin, ethnic origin, family status, marital status, gender, gender orientation, gender expression, gender identity, and all those things are similar but different. They have their own definitions and their own expectations and their own reasons for being out there, including disabilities and others. And disabilities could be mental or physical. So when we talk about family status, for example, that means the relationship between the person, the employee, and the child, or the employee and the parents of that employee. So that's a family status. So when we're talking about leave of absence, right? And then in the Employment Standards Act, the minimum standards, and then the employee returns to work. But now the employee has a child who is, I don't know, kindergarten age. The employee may be experiencing challenges with childcare. So now the parental situation that was in the leave of absence now becomes some sort of accommodation or adjustment that needs to happen in the workplace to remove barriers for that employee who is a new parent, who has challenges with childcare, in order for the employee to continue working with dignity and attend to the duties that they have as a parent, right? So I just wanted to brought this a little bit beyond the minimum standards, a little bit of human rights as well. And on top of that, we have health and safety in workplaces. And I'll go back to Employment Standards Act after this. In workplaces, it doesn't matter if we're talking about a construction site, if we're talking about scuba divers, if we're talking about offices, environments, health and safety is part of the workplace. The danger in those type of works in different type of work may be different. The dangers and the hazards that you're going to be seeing there, but every workplace has health and safety that requires to be reviewed, and decisions need to be made about that. The three things, global things that the health and safety will cover are hazards, evidently. So that means floods and fire and wearing protective equipment and all those things. That's hazards. Chemicals, right? And also harassment. So harassment in the workplace, which is a behavior from somebody that it's not welcome, that has this impact on the person that it's not okay. And the other thing that the Health and Safety Act have, or the health and safety in general will have, is the protection against violence in the workplace. Sometimes in the office, you don't see that violence happening, but in a construction site, you may see that happening. Or in a high-paced, stressful environment, with a lot of stake in place, you may see violence happening. And violence is not just the physical action to cause injury, but it's also the threat of causing an injury, even though the injury didn't happen. So that's also violence. I have a question here. How about microaggressions? What it is allowed by the company culture. So I'm cautious about words like microaggression, bullying, all those words, because a person may feel that it is a microaggression. A person may feel that it is bullying. The label that the law has is harassment, which may, so bullying can be harassment, but it requires that it gets to a certain standard. The same thing with microaggressions itself, like today I call you a name, and tomorrow somebody else made a joke, different person made a joke about something else, and so on, right? It may be together that it gets to the point of harassment, but it needs to be assessed first. Subjectively speaking, I feel hurt by all these things that are happening. Objectively speaking, well, these microaggression, whether 1 or 2 or 5 or 10, would that amount to harassment as the label that the law has? So that's a question of assessment, and the employers will have that duty of assessing whether these microaggressions are harassment or not. And if they are harassment, then they need to take steps to prevent those microaggressions from happening again. If they are harassment. If they're not harassment, it would be wise, even though we're not talking that it is illegal, the microaggressions, if it's not harassment, then the employers would be wise if they stop those behaviors, because they will accumulate and they will escalate to a point where it will become harassment. So we call that, it's not in the law, but we call that civility in the workplace. So being civil in the workplace. So when we talk about sending emails to make you look bad, or shouting for no reason, not at you, but at somebody, and it looks bad. So these things, even though they're not illegal against an employee or against a worker, and it's not harassment itself, the employer would like to tackle those so they don't escalate to something worse. How about documentation of the events? Yes, so that's a great question. I conduct workplace investigations as well, and I'm called to talk with employers and employees about whether there was harassment in these, for example, microaggressions, right? Somebody complained, or the supervisor saw something that needs to be assessed. So I go in and I review. I always ask for, do you recall what happened? Do you have notes that you took that day? And other things. So if something happens in the workplace, the best thing that you can do, if you don't know what to do exactly at that moment, but you think that is concerning, when you get home, the first thing that you will do is just write it down, whether in your computer, your phone, or somewhere. This is what happened today. The person yelled, or the person called me a name, or whatever it was. The name of the person, was somebody else around? Was there a witness? My coworker was there, and the name of the coworker. What time did it happen? Where did it happen? All those little details are important, because that will give context to whether those microaggressions, as you mentioned, are harassment or not. Great questions. All right, I'm mindful of the time. Let's move to, okay. And this is the last slide I have for the purposes of the Employment Standards Act. I will mix a little bit of contract with this, but feel free to ask questions after we finish this. So terminations and temporary layoff. I don't know if you've heard, and I ask you this question. Have you heard the word "I was laid off" often, or you haven't heard layoff before, with a Y or an N? Yes or no in the chat. Layoff. Yes. All right. All right. So a lot of people uses the word layoff. I was laid off to say I was terminated. I don't know. It's like a um, like a habit, like a costume, like a cultural thing that we say I was laid off instead of termination. The word laid off or layoff in the Employment Standards Act, there's only one layoff, and that's the temporary layoff. Temporary layoff. And the temporary layoff is that the employer sends you home for a short period of time. Temporary layoff. There is no other layoff. The other layoff is termination. That's it. So the layoff that people refers to, oh, I was laid off, is termination. But there is a temporary layoff, and I think that you yeah, it sounds nicer. Exactly. That's that's exactly it. It sounds nicer layoff than termination. Correct. But technically speaking, these are two different things. And you've heard a lot of oh, I was temporarily laid off during the pandemic. A lot of people was temporarily laid off because of the pandemic, and the time was extended by the provincial government and others. So it was actually, we still have temporary layoff window until July, the end of July, I think, 2022. So we still have a window of temporary layoff because of the pandemic, because of the emergency. So the regular temporary layoff, the general temporary layoff, is 13 weeks. That's the maximum. An employer can send you home for 13 weeks because there's no work, because it's a season type of employer, for any reason. There needs to be an agreement, though, between the employer or the employee. Otherwise, it would be a dismissal in a different way. But let's assume that there is an agreement, and the employer sends you home for 13 weeks or less. It doesn't matter. I mean, the time cannot be more than 13 weeks. If it's over 13 weeks in a period of 20 weeks, so it could be 2 weeks here, 3 weeks there, 7 weeks there, right? So 13 weeks in a period of 20 weeks. If you cross the 13 weeks, then it becomes a termination. It's not a layoff, but a termination. So be mindful with, and there are other rules about that, but I'm mindful of the time. Let's talk about termination quickly. With letter A, B, or C, time, pay instead of time, or nothing, what do you think a person is entitled to when the person is terminated? A notice, so time, I tell you, listen, by this date, you're going to be, the employment ends. Pay instead of that time, or nothing. A, B, or C. A and B, all right. A and B, A and B, okay, good. What about if the termination is with cause? If the termination is with cause, there is no time, there is no pay instead of time, right? So it depends, again, what type of termination it is. Termination with cause is very complicated, but it happens. Now, one thing that you need to be mindful of about termination, there are two different systems or regimes for termination. One is the minimum standard, and the minimum standard is capped at 8 weeks. Let's say, let's not talk about severance pay because that's a different story. Let's talk about 8 weeks of termination pay or notice. So A or B, time or pay instead of time. So 8 weeks maximum. For those employees who have 8 years of seniority, length of service or more, they can have 20 years, they can have 30 years. It's always going to be capped at 8 weeks under the Employment Standards Act. If the Employment Standards Act doesn't apply, then we're talking about, for a person who worked 30 years, for a person who worked 25 years, we could be talking about 2 years of notice, so 24 months. So the difference is substantial. The difference happened because the employer has an employment agreement in writing with a termination clause that it's valid, that says when you are terminated, you're going to be terminated by the employment with the Employment Standards Act regime. And if you agree with that, then sign the agreement and you start working with me. So if that's there, then the Employment Standards Act applies. If that's not there, then employers may say, well, I'm going to pay you minimum standards 8 weeks, but the employee may be entitled to more than that. And with that, I think that we cover all the things that we needed to cover.